Let us examine the perspectives of rights and duties. In this lecture, we will briefly summarize the concept of right and duty. This lecture will present only an overview without resorting to the theoretical controversies that surround various rights and duties. It will examine the relationship between rights and duties and the significance of values that bind on individuals while exercising their rights and discharging their duties. The word right had been used with different nomenclatures across the world in various periods. Basing on different expressions, there is a considerable debate in the academic fields like political science, philosophy, anthropology, and in law about the foundation, meaning, and function of right in different contexts. In general, right in its objective sense may be described as just actions of individuals which have to be discharged to promote harmonious relationships in their transactions between themselves. From a legal point of view, a right guarantees certain freedoms and liberty to be exercised by individuals in their transactions with other counterparts of a society. In an analytical point of view, right consists of two parts. One is the form and the other is the function. Accordingly, right is a combination of claim and duty. Right confers certain liberties and imposes duties upon individuals to exercise while claiming their rights. For example, A has a right to food. This means to achieve the right to food, A has to undertake some kind of work to earn his food. Accordingly, the right to food is coupled with a duty. In a legal perspective, rights are two types. They are positive rights and negative rights. A positive right is an entitlement of some provision of good or service. A holder of negative right is entitled to non-interference by others. For example, the right to privacy constitutes as a negative right. In a nutshell, a right confers a person certain amount of liberties and privileges. Possessing a right should also enable a person to exercise it. A right holder need to discharge the obligation or duty first before the entitlement of the right. This can be better achievable only by imparting human rights education. Human rights education principally teaches a person the way one has to claim their rights without injuring the rights of others. Right being the core concept of life and liberty, it has different types in its exercise. The rights are natural rights, legal rights, claim and liberty rights, positive and negative rights, and group rights. Let us examine these rights in detail. Natural rights. Natural rights are rights which are inherent in man. Any law, government, or any state does not sanction them. They are universal in nature. These rights are sanctions of God. They impose a duty on man to discharge the responsibilities. These rights are referred to as inalienable rights. Right to life, liberty, happiness, etc. are considered as natural rights. This picture clearly expresses the freedom that individuals have as representatives of God in their life. However, in the age of enlightenment, a number of scholars challenged the divine concept to natural law. According to a number of advocates in the Western world, especially thinkers like Hobbes, Locke, Grotius, and Rousseau, etc., natural right means the people in a territory agree to form a government of their own and establish common rules and regulations framed either by the people or the government. These rules and regulations need to be discharged by people with duty, consciousness in order to promote peace and security. This being the central philosophy of natural law, and natural rights, there exists a difference of opinion among the various scholars of natural law. A section of scholars, especially modern naturalists, argue that both human rights and natural rights are one and the same. According to them, since the philosophy of natural rights and human rights apply universally with certain legal regulations adopted by man through government, both are one and the same. But from a traditional point of view, since the natural rights are a gift of the God, they can never be equate with that of human rights. Man drafted human rights, whereas natural rights are divine gift. Now, the second one is the legal rights. Legal rights means rights that are guaranteed to a citizen of a country by a government through a statute. For example, right to information is a legal right. However, in legal rights too, individuals have a duty to exercise them properly and not to exceed the limits prescribed by law. Claim and liberty rights. Claim rights are the rights that impose an obligation on another person to respect the right of others. Liberty rights are the rights to be exercised at free will by the holder of rights without any obligation or any other person in exercise of his right. Right to speak freely is a liberty right. But at the same time, this right of speech need to be exercised carefully without affecting the reputation or right of another person. Positive and negative rights. Positive rights means rights for which a person or a government is expected to discharge some service to people or as a whole to the society. Negative rights impose an obligation not to interfere with the liberty or independence of another person. It is difficult to draw a distinction between these two rights. These two rights coexist with each other. Examples of positive rights are right to education, right to health, social security. In the language of human rights, these rights are described as economic, social and cultural rights. In the Indian context, these are referred to as directive principles of state policy. Examples of negative rights are right to equality, right to freedom of speech and expression, right to life and liberty. These rights always impose a moral and legal duty upon individuals not to cause injury to the other person or to their rights. These are referred to as civil and political rights. In the Indian context, these are referred to as fundamental rights. Individual and group rights. Individual rights are mainly rights that belong to an individual. Group rights means rights that are sanctioned to a group together to enjoy. Disabled rights, which are sanctioned commonly to all the disabled persons. These are called as group rights. The brief discussion presents clearly that a right not only sanctions to an individual to exercise the right freely, but also at the same time impose a moral, legal, social obligations to discharge simultaneously while exercising the right. Next, universal rights. Universal rights means rights that can be exercised by people universally all over the world without any interference by any authority or state within the legal limitations. These rights impose obligations on each country, state to protect and promote them at all times without any discrimination to sex, race, language or religion. The former President of the United States of America, Mr. Franklin D. Roosevelt, in 1941 on January 6th advocated freedom of speech, freedom of worship, freedom from fear and freedom from want as the basic principles for the dignity of an individual to lead a dignified life. Based on these principles, the United Nations in its charter adopted on October 24, 1945, gave birth to the words human rights, recognizing the civil, political, economic, social and cultural rights of the individuals across the world and imposing the duty on the nation states to protect them. Before we proceed to examine the concept of duty and the relationship between right and duty, let me explain the elements of a right. A right contains 5 elements. Number 1, a right holder, the subject of right, has a claim to. Number 2, some substance of it, the object of a right. Number 3, which he or she may assert, demand, enjoy or enforce, exercising a right. Number 4, against some individuals or group, the bearer of the correlative duty. Last, the 5, citing in support of his or her claim on some particular ground, the justification of it. From these elements, one can understand that to exercise a right, at least 2 individuals are necessary. The claim of the right must be legal in nature. Nature and concept of duties. Normally, we all consider obligation as a synonym to duty. From a legal point of view, duty and obligation are 2 different aspects. According to Professor H.L.A. Hart, a duty is linked with a right at all times, whereas an obligation is not linked with either a right or a duty at all times. Let me explain this with a simple example. A's wife asked him to come home early in the evening. A agreed to come at 6 o'clock in the evening. This means A has an obligation to reach home at the scheduled time promised to his wife. But due to some other work at the office, he could not return to home as promised. By not returning home, he has violated or breached the right of his wife. The acceptance to come home at the scheduled time is only an obligation, but not a duty. If a duty is not coupled with any act, then such act constitutes only an obligation, not a duty in the legal sense. From this example, it is clear that duty and obligation are 2 different aspects. They are not synonym. This is because the obligations are expected to be fulfilled to the possible extent. It is referred to as duty. Let us examine then what is a duty. A duty is normally linked with obligation. The concept of duty arises from a fulfillment of a requirement. In this sense, duty should be classified as moral, legal, parental, societal and many more. From the legal point of view, a duty arises strictly from a legal norm or requirement. It further arises only in the way it is expected to discharge the right or legal obligation. If one acts contrary to a legal duty, it constitutes as a breach of duty or wrong. For example, a legal norm says not to be corrupt. If one indulges in corruption, it constitutes as wrong. Right and duty coexist with each other. They are 2 sides of a coin. They are reciprocal to each other. A right is a demand and a duty is an expectation. Like right, duties are also different types: natural and acquired duties. Natural duties are duties to be discharged by every individual voluntarily. For example, not to tell lies, not to harm others, not to escape from the legal duties, etc. Acquired duties are duties accepted by individuals either by voluntarily or relationships that they have with other counterparts. In this sense, some duties may constitute as legal and other only basing on the willingness of the individual to discharge the duties. Positive and negative duties. According to John Rawls, a contemporary American jurist, positive duties require everyone to do good at all times. Negative duties impose restrictions on doing bad. Perfect and imperfect duties. Though these 2 appear similar, to positive and negative duties, according to Professor Immanuel Kant, they are not similar to each other. Perfect duties expect individuals to discharge the incurred obligation as per the goal that is set all times without deviation. For example, if X wants to achieve a gold medal in his sport, he has to concentrate on his energies to achieve that in a legal manner. Imperfect duties are duties that are never completed in its true spirit. The performance of these duties depends on circumstances, prima facie, and all things considered as duties. According to W. D. Ross, many a times people perform their duties depending on the advantages and disadvantages. This being the primary concern in discharging a duty, Ross advocates that individuals to be rational in discharging their duties in a proper manner without harming the interests of others. Human rights in general, coupled with the duty perception. To achieve the common good in society, everyone expected to discharge their duties properly and which are legal, at least while exercising their rights. In order to augment this value system in the world, basing on the request of number of scholars and Nobel laureates, the United Nations adopted a declaration on duties of humanity. The General Assembly, basing on the request in 1999, adopted a declaration on responsibilities and duties of humankind. The declaration specifies duties on various fronts. Few of them are discussed here. Rights and protections accorded to human rights defenders. The declaration provides specific protections to human rights defenders, including the rights to seek the protection and realization of human rights at the national and international levels, to conduct human rights work individually and in association with others, to form associations and non-governmental organizations, to meet or assemble peacefully, to seek, obtain, receive and hold information relating to human rights, to develop and discuss new human rights ideas and principles and to advocate their acceptance, to submit to governmental bodies and agencies and organizations concerned with public affairs, criticism and proposals for improving their functioning, and to draw attention to any aspect of their work that may impede the realization of human rights, to make complaints about official policies and acts relating to human rights and to have such complaints reviewed, to offer and provide professionally qualified legal assistance or other advice and assistance in defense of human rights, to attend public hearings, proceedings and trials in order to assess their compliance with national law and international human rights obligations, to unhindered access to and communication with non-governmental and intergovernmental organizations, to benefit from an effective remedy, to the lawful exercise of the occupation or profession of human rights defender, to effective protection under national law in reacting against or opposing through peaceful means acts or omissions attributable to the state that result in violations of human rights, to solicit, receive and utilize resources for the purpose of protecting human rights, including the receipt of funds from abroad. The duties of states. According to the declaration, states have a general responsibility to implement and respect all the provisions of the declaration. However, some of the provisions make particular reference to role of states and indicate that each state has a responsibility and duty to protect, promote and implement all human rights without any discrimination towards race, sex, language and religion, to adopt such legislative, administrative measures with an effective remedial mechanism for their violation, to conduct prompt and impartial investigations of alleged violations of human rights, to take all necessary measures to ensure the protection of everyone against any violence, threats, retaliation, adverse discrimination, pressure or any other arbitrary action as a consequence of his or her legitimate exercise of the rights referred to in the Declaration, to promote public understanding of civil, political, economic, social and cultural rights, to ensure and support the creation and development of independent national institutions for the promotion and protection of human rights such as ombudsman or human rights commissions, to promote and to facilitate the teaching of human rights at all levels of formal education and professional training. The responsibility of everyone. The Declaration emphasizes that everyone has duties towards and within the community and encourages us all to be human rights defenders. It is the duty of every one of us to promote human rights, to safeguard democracy and its institutions, and not to violate the human rights of others. It further emphasizes the role of professionals and practitioners, especially that of police officers, lawyers and judges as defenders of human rights. The role of national law. The resolution also imposes a responsibility on the states to implement these principles and promote them by adopting appropriate legislations. The Indian Constitution has already incorporated the duties through the 42nd Amendment Act way back in 1976. Impact of duty on the society. Every individual has duties towards the state or society. According to the Universal Declaration of Human Rights, the duties of each person towards the state are to obey the law, other legal commands of the state and its agencies, to render the services in civil and military affairs whenever required by the state for its defense, to cooperate with the state and the community with respect to social security and welfare to the extent possible, to pay the taxes established by law for public purposes, to protect the property and culture of the state. The duties towards society are in general to respect the women, children, wounded, sick and elderly persons, rendering charitable work through social service, education, religious activities, cultural activities, etc. To respect the rights and responsibilities of others, not to make false allegations or complaints against others and misuse of legal mechanism, not to discriminate or advocate anything on communal, linguistic and religious or any other ground that affect the liberty of other individuals, to follow and obey the moral and ethical values that belong to each society. Apart from these duties, the other duties that are specified by each instance in every society need to be followed strictly. Duty as a value. Since actions of an individual are based on choices and the behavior, duty being one of the main components of value system, it inculcates a number of values in individuals. From ancient to modern times, a number of scriptures and statesmen and religious texts of various faiths advocate the duty-based value system, which regulate unnecessary temperaments of individuals and promotes a healthy society or state. The Universal Declaration of Human Rights through Article 29(2) clearly imposes duties of public and moral character to be exercised by individuals claiming their rights and freedoms for the promotion of welfare, state or society. Let me reproduce the article. In the exercise of his rights and freedoms, everyone shall be subject to such limitations as are determined by law, solely for the purpose of securing due recognition and respect for the rights and freedoms of others and of meeting the just requirements of morality, public order and the general welfare in a democratic society. This brief discussion clearly signifies that duty constitutes as the first basic value of an individual to be exercised at all times without any deviation before expecting the rights to be protected or exercised. Interrelationship between rights and duties. The two phrases rights and duties coexist with each other. In other words, the two are two sides of a same coin in regulating the values and behavioral patterns of an individual. On one side, rights are important in developing the human personality and behavior. The duties, on the other hand, direct individuals the importance of their contribution for the promotion of social good. In a way, duty targets at the realization of rights guaranteed by various laws and regulations both nationally and internationally. According to Professor Harold J. Lasky, the interrelationship between rights and duties is A. One's right implies the other's duty. B. One's right implies one's duty to recognize similar duties of others. C. One should exercise his rights for promotion of social good. D. As the state guarantees and protects the rights of everybody, one has a duty to support the state. Let me summarize the entire lecture briefly. Rights. Rights have different meanings. In the eye of law, there are legal and moral entitlements which need to be adhered by everyone. Right has a legal sanction which can be claimed for its breach. Natural rights are rights which entitle a person to enjoy freely by birth. Legal rights are rights that are sanctioned by law to individuals to enjoy their rights freely without any interference subject to the limitations of law. Claim rights means a person who can seek a legal remedy in the infringement of the legal right. Liberty rights are rights freely exercisable by every individual without a sanction or duty on other person. For example, laughing and practicing a religious act. Positive rights are rights otherwise described as dependent rights which may be exercised on their guarantee by state or society. These are described as economic, social and cultural rights. Negative rights which impose a duty on a person to respect the right of another person. These are described as civil and political rights. Individual rights are economic, political and or legal. They belong to individuals to enjoy their freedom and liberty. They want to exercise their rights. Group rights are rights that belong to particular group of people in a society. They may often differ from the general rights of others in society due to particular significance given to them. Universal rights are rights that belong to people across the world without any difference to race, sex, religion, language or any other social, economic, political or legal affinity. Let me explain duties briefly. There exists a difference between obligation and duty. Obligation arises mostly from ethical and moral perspective. Duty arises out of responsibility which is legal in nature. Natural duties bind on all of us. Acquired duties are duties that are obtained by discharging a particular duty. Positive duties impose obligations to do good. Negative duties prevent us from doing bad things. Perfect duties expect us to be sincere and imperfect are many which may not be supported either morally or legally. Individuals have duties towards state, society and to themselves and to their family. Duty is the first value that needs to be discharged for the promotion of good in society and to themselves. Rights and duties have an inseparable relationship which cannot be separated at any point of time. Adhering to duties is nothing but adhering oneself to be dutiful and doing good to society and state. In conclusion, from the lecture, we understand that rights and duties have an inseparable relationship. Any individual wants to exercise his right, first of all, such individual has to discharge the duty. Without discharging a duty, one cannot cluster or clamor for rights. Such cluster or clamor without discharging the duty will only result in negatively affecting the right, but not to gain the positive sanctions that are sanctioned by law.